To be moderating this webinar today with a distinguished panel of our Jefferson County Family Court judges. We have with us Chief Judge Tara Hagerty, Judge Christine Ward, Judge Denise Brown, and Judge D. McDonald. As they are talking and sharing, if you have questions that come to mind, please type them in the Q&A panel, and I will review through those and ask questions as it becomes appropriate. Judge Hagerty, I'm going to turn it over to you.
Thank you, Dorislee, and thank you to the Mary Byron Project, both for hosting today, and for those of you who don't know, the Mary Byron Project has recently donated 4 laptops to Family Court. I believe Judge Brown and Judge Ward may talk a little bit more about that in a little while when they discuss the remote hearings that we're doing and our attempts to accommodate pro se litigants. But thank you very much for that donation. That's helping us do some remote hearings to keep everybody safe in more ways than one. So thank you. On behalf of all of us, the 4 of us here today and the other 6 judges, thank you for participating today, and thank you for everything that you're doing to serve your clients, to keep your practices going. We understand what a trying time this is for everyone personally and professionally, and especially for attorneys who spend their time serving clients who are in crisis under the best of circumstances. Now everybody's in crisis and under very, very challenging circumstances. We understand that, we appreciate that, and we're trying to do everything that we can to make access to court available for your clients. As you are anticipating, the Supreme Court is going to be issuing an order that reopens and expands more court services beginning on June 1st. We'll be talking about that today. In the interim, pending June 1st, please note that the Domestic Violence Intake Center is still open 24/7. So if your clients are in need of petitions for emergency protective orders, that service is still available in the Hall of Justice. Our domestic violence dockets are running just as normal. They have been for the entire limited services time. So each of us has a domestic violence docket once a week. Parties and counsel are given the opportunity to appear remotely, but they also have the opportunity to appear in person, as that is one of the exceptions under the Supreme Court order. Our dependency, neglect, and abuse dockets are being heard remotely in terms of annual permanency reviews and other types of hearings that have statutorily mandated time limits. Emergencies are being heard remotely if parties choose, or they can come in person. Circuit cases, as most of you know, we are doing motion hour by taking things under submission. That is limited access and a little bit delayed access. We realize that. We're working diligently together so that on June 1st, we can provide more remote access to motion hour and have cases called, at least to some extent. Most judges are also offering limited circuit hearings. So if you have a matter that may not rise to the level of an emergency, but you think it's time sensitive, you certainly can request a remote hearing from the court, and the judge will have discretion to hear that before June 1st. We will be getting out more information about how the June 1st reopening will look as soon as that's complete. I'm representing Jefferson County on a statewide reopening task force. We've met once. The next meeting is tomorrow. And one of the biggest challenges that we're dealing with are respecting the guidelines for everybody's safety with the reopening. And by that, I mean wearing masks and having the 6 feet personal distance space. So, you know, that's a big challenge with as many people who come into the Judicial Center. So that's one of the things that we're working through. With that said, I think I'm going to turn it over to Judge McDonald. We had sort of split up some things that we thought you would want to hear, to share some information. And obviously, as Dorislee said, we're open to questions. Judge McDonald had put together some information about some questions that are frequently asked or that we anticipate you may be wanting to ask, and she's going to share that information. So Judge McDonald, I'm going to turn it over to you.
Thank you, Judge Hagerty. Thanks everybody for being with us today. We hope that this is as informative for you as it has been for us putting it together. I have a few things that have been brought to my attention either by the other judges or by counsel that I'm going to briefly go over, and then I'm assuming that there will be lots of questions that I've not touched on. One of the most important things we've been getting lately is an issue about what to do if the parenting time is being violated. There's a court order in place and they're saying somebody has coronavirus or they've been exposed to it. We will send out, if you want, if you don't already have, and I assume you have it, the Supreme Court order that guides us as to when we can change parenting time during this without a hearing. If the order is not being followed and it's not part of the Supreme Court guidance, then file a motion for contempt. The judge in that division will determine whether that's an emergency issue, and if so, they may set it for a remote time. They might set it out later. What I have done is had what I call a case management conference and gotten the attorneys on. So we're trying to be as flexible as we can and address these issues as they come through. When I have denied a motion like that, I have sent a copy of the Supreme Court order in the order denying the motion. I don't know what the other judges are doing, but I figured that was a good way for an attorney to be able to show the client why the judge is denying that. Along the lines of contempt motions, again, we're getting questions about what happens with child support and maintenance not being paid. File a contempt motion. It may be set for a remote hearing. It may not. Certainly maintenance might be an issue, more so right now than child support. But if somebody's not working because of COVID, then as with the child support issue, we have to look at the not willful issue. Maintenance is something else, but if they're not working, they're not working. So some judges may give a remote hearing. Other judges, like me, will probably pass it 2 or 3 months down the road in hopes that people are going back to work and the issue will rectify itself. Some counsel have questioned whether attorneys can file motions or not. By the looks of my Monday motion hour motions coming in, I don't think most people have that issue. But if that is a question for you, pleadings can certainly be filed electronically, as they have been for years, or they can be placed in the drop box in the ante room of the Judicial Center. If you place them in the drop box, they are collected every hour and they are immediately time-stamped upon collection. It is our understanding through the clerk's office that attorneys may enter the Judicial Center to review and look at files at this time as well. Again, as Judge Hagerty mentioned a moment ago, if the judge in your division determines that your issue is an emergency, you will be given a remote hearing at that time. Another question that I've gotten a lot from everybody is, can you all please be consistent on your motion hour? Okay, guys, the answer is no. We're not all going to be consistent, but we're certainly looking at ways we can try to be more uniform that will help you as well as hopefully us. We're looking at having a set time for all 10 divisions to post their pre-rulings for motion hour. I hope that would be of benefit to you. Everybody seems to think that would be from the bench. Each division is still going to address their individual cases as they have been. And again, as Judge Hagerty mentioned, most of us are looking at trying to have some form of a remote ability for some of the cases that come through at motion hour. One of the questions I've received several times is if, like for instance, a friend of court is having issues addressing a child during this pandemic, what does the judge want them to do? I have allowed attorneys to get in touch with my secretary and set up either a conference call for all the attorneys and or through my secretary, email me jointly so all the rules are followed, but sometimes I can address issues much more quickly in that manner than having you try to file motions and wait for me to review them and wait for somebody to respond. So I would suggest, if you are interested in doing that, contact the secretary for that division, and that secretary can either speak with the judge, or they probably already have an agreement between them on that, and the judge can be told of your interest in that and pull the case for the judge and set up something. And that's pretty much all I have right now. So I will pass it to Judge Brown, I believe, is coming up next. Is that correct, to talk about remote?
I think that is. Thank you, Judge McDonald. I wanted to talk just a little bit about the courts conducting the remote hearings and the challenges that we are facing in conducting those. But first, I just want to reiterate some of what Judge McDonald just discussed, and Chief Judge Hagerty as well, that, you know, the way to get into court to request the remote hearing is, you know, basically by filing a motion, or you can place a call to the secretary in regard to an issue that you feel is emergent in your case. And then at that point, the judge will make a decision as to whether the remote hearing is granted. And then, of course, the DVIC Center has been open the entire time, and our EPO dockets are running weekly. So all of those things are happening each week in each respective judge's courtroom. So there's, you know, no need to do anything special there. You can just simply file your motion, and it will usually get heard in the next week. We are primarily using Zoom and Skype. And, you know, today, for purposes of the LBA, we are using Ring Central. And that seems to be a pretty good platform. One of the drawbacks with Skype is that it usually requires that you download the app before you can use it. And you don't usually have to do that with Zoom. So I think we're maybe equally split between the judges using Zoom and Skype. We have all been trained in one or the other, and some have been trained in both. And it's basically the judge who is hosting the meeting will send you the link on how you can have your remote hearing. In your remote hearings, you will be able to share exhibits, and we are asking that the parties provide those exhibits in advance of the hearing so that it can be shared on one screen, especially in the case of attorneys. If you have them, you can send them to the other side. And if there's a pro se litigant, we want them to have the opportunity to look at them as well before they are used in the hearing. But we are, you know, making adjustments in the event that the information is not available until just before the case starts, especially for our EPO dockets in Deana. Sometimes it just becomes available that day. So we have some flexibility in terms of, you know, the time frames. But if you have a hearing that's set on a circuit case, you're typically going to get a trial order or a hearing order, and it's likely going to give you some time frames for when you should provide that electronic data to the court. The litigants will be able to present that data through the share option. There's a share option on Zoom and in Skype, and Judge Ward is going to go over that and show you all what we are looking at for that. And I guess one of the biggest issues that we may be having now is in regard to the technology is making sure that the attorneys are able to use the technology. Quite frankly, really the litigants have been all over it. I mean, they're able to really do a lot more than what we've been able to do. Right. And we do allot some time within your appointment time, your remote schedule time, in case we have hitches with the technology, or you can't get on, or we can't hear you. We've allotted a little extra time to be able to handle that. But it is our hope that if you call in early, let us know that you're having some difficulty, because we'll usually try to log in early as well to see if we can hear everyone. And let's see, we're scheduling the hearings for short periods of time, at the most 2 hours. And that's not really the preferred amount of time, but we can go up to 2 hours. 3 hours is really a stretch in terms of the technology holding up and the ability of everybody to be able to hear. It seems that when we do hearings that are longer than 2 hours, our connection is just not always stable. And so sometimes that doesn't work out as well. And we would like to have everyone call into the same platform because that helps us as well with communicating. Everyone can hear the same thing. There's no delay. There's no echo in the recordings, and we are also recording them directly into our JAV system, and we have the backup of recording them in the cloud or on our desktops with the respective platforms. And so our secretaries are making those copies just as they normally would on an everyday basis to get them down to the media room in the event that you would like to have a copy. We are accommodating pro se litigants who may not have data to be able to do this by video. So we are allowing them to do it by audio only. Most of the invitations will have a video and an audio only link. So if you're only able to participate by audio, that is fine. And if you want to, we would like to make sure that everybody's on the Family Court Administration email list. And I think Christine is going to come back and talk a little bit more about that. I don't know if you had any questions. I see something in the chat area. Are there any questions for us, Dorislee?
Thank you, Judge Brown. There was one suggestion, if you could speak louder or move a little bit closer to your mic. I think some folks are having a little bit of trouble hearing you. I did just have a question come in. Someone asked about, you said that if folks could call in using the same platform, and they were curious, I think not understanding that comment, that if they all click on the same link to a Zoom meeting, for example, that would comply with what you're asking. Is that right?
That would definitely normally do that in that case, but sometimes folks may get confused and then they may call the office saying I can't get in, and then just want to join by audio. And if there are other parties in the courtroom, we can usually work with that. But if you're the only person that's on the different platform, then sometimes it can create a problem. But we'll try to accommodate it because this is new for everyone. And part of me sitting back from the camera and not talking as loud has to do with the echoes and the feedback that we get in the courtroom when we're using the all of the different devices. But you know, I don't have anything set up in the courtroom right now, so I probably should have been freeing a little bit closer.
I can follow up on Judge Brown's comment and the question a little bit as well. We are, as we've said, we're trying to accommodate everybody with whatever vehicle they have to participate. So we will frequently have folks who are participating by telephone, not as part of the Skype or Zoom meeting, but just a call from the bench phone to them. And we're recording on JAV so that it's not just captured by Zoom or Skype, but also on JAVs. And what we're finding is with participants participating by telephone and Skype or Zoom, they can't always hear each other very well. And I was told in our statewide meeting that the Administrative Office of the Courts has noticed that it's difficult when we have multiple platforms like that in use for JAVs to pick up everything. We're going to do the best we can to work with that, because some people, especially some of the pro se litigants, just don't have the ability to use Skype or Zoom. But that's something to be aware of if you have witnesses that you're calling. If they could participate in the Skype or Zoom, that's preferable than having a witness just call in on telephone.
Judge Hagerty, I've had, someone ask what JAVs is, if you wouldn't mind to just tell folks what that is.
Yeah, JAVs is, you know, when you get ready to start a hearing and you see us sort of fooling with our computer and then the red light goes on. JAVs is our recording system in the court that records by video and audio. And just as in an abundance of caution, and also in those cases when everybody is not part of the Zoom or the Skype hearing, we're recording on JAVs concurrently if we're in the courtroom. So that, I don't know what JAVs stands for because I've never actually heard that, I don't think, but that's our recording system in the courtroom. Thank you.
Thank you.
Is it Jefferson audio video system maybe?
That sounds right. That's a good answer. I'll go with that.
So I'm going to go
Judge
ahead
Brown, if I could.
to Judge Ward. Oh, do you have a question, Dorislee?
Yes. You mentioned the screen sharing for the exhibits, and are those captured in the record? And also, have you had anybody attempt to play any recordings? How is that done? How does that work? Do they go into the record, that sort of thing?
Well, with the, thankful to the Mary Byron Project, that is one of the reasons why we want to have the extra laptop in the courtroom, because it can be connected at counsel's table. And once it's connected at counsel table, then everything that is said, including the Zoom or the Skype call, is recorded into our JAV system. And so that means that the exhibits, as they are presented on the screen, are recorded into the JAV system. So if they were present in court and they brought the paperwork in with them, we would probably just put that on Elmo, which is like the smaller device that's right at the witness, at the witness chair, where you can place the exhibit on top of that and make sure that it gets into the record. So we're still using the old way of doing it, but in order to make sure that all of the information that's presented during a video hearing is included in the record, we are having a setup at counsel table of another computer, which allows all of that information to be recorded.
Let me just add to that. So yeah, certainly we're so glad to have these extra laptops, because one, it's just more efficient, and that way we know that we're capturing everything, but we are still recording. So like if I were recording this proceeding right here and somebody shared their screen, it is going to be recorded. So when you go back and look at the recording, you are going to see, but it's in the, if I'm using Skype, it's in the Skype recording. If I'm using Zoom, it's in the Zoom recording. And it is all kind of new, and it basically is an extra step for our secretary to, or our IT people to come up and make sure that gets downloaded and burned to a CD and then sent to our video office, the clerk's video office as well. But so we're doing it in both ways right now. But if we once we get all these laptops set up, we'll be able to just record from directly into the JAV system, and then we don't really have to worry about worrying about, do we remember to record everything. But that is one of the tips on our tip sheet is, so first of all, we don't want anybody else recording these proceedings. So when you join in, we should have it set where you can't record, but I don't think anybody's going to be offended if you, what I try to do when I start a hearing is I say, I am on the record now, or I just let you know that I am now recording this. So if the judge doesn't say that, you might want to just make sure, Judge, did you remember to turn on the recording? So I don't think anybody will be offended if you say that. So I'll just let you know that. Go ahead.
Judge Ward, were you going to address the sharing of the screens in your section? Because
yes,
I'm a dinosaur, and I'm sure there's a couple of other dinosaurs out there that don't understand what that means.
Yeah, so I can share my screen right now with you all. And so I'm going to show you exactly, you'll kind of see a screen within a screen. And so basically you're seeing now what I'm seeing. Now you're seeing my little tips sheet right now, but let me see if I wanted to share the big screen. Oh, there's D. It made my screen small when no, okay. It's not going to let me share. Well, I was trying to share my big screen here.
If you're sharing a document, Judge,
I was going to show you how to share, but I can't get the, okay, so here, now my little button is at the top. It's usually at the bottom. So if I had to share, there's a little folder, and it's the same on Zoom or Skype, but there's like usually a little folder, and when you click share, then it lets you choose what on your computer you want to share. So I'm going to stop sharing now, but I could share different things, like, and that's why I was going to share some other stuff with you all as well. But you should be back to normal speaker view now, hopefully.
when you're sharing documents, Judge Ward, does the document need to be downloaded into the device you're using at that moment in time?
So not necessarily. So I've had, well, I mean, I guess it does. I don't know about downloaded, but is, you know, like you could share exactly what's on your email right now, or you could share any screen that you can see on your computer screen in front of you. You have the ability to share that with the court. So you might want to, if you're planning on doing that, you might want to be careful and make sure you've closed out anything you don't want anybody else to see before you get on your Zoom or Skype conference. But yeah, you can share. And I do usually it depends on how the person has set the meeting up, but they might have to give you that permission to share first. So you might, and I think that's probably good practice. So I'll just ask, Judge, can I share this? Because we've talked about in some of the hearings I've had of, so how do I, you know, authenticate this? I want to show you this photograph. How do I authenticate that beforehand? So that does require that you have, before that hearing, shared that with the other side. You could email it to them, or, you know, hopefully if it's, and I think it's more of a problem if it's a pro se litigant, and we've just had to handle that as they come. But essentially you would just, you know, ask your foundational questions, and if I think that you've established the foundation, I'll let you share your screen and take it into evidence.
Judge Ward, was there more information that you wanted to share about these topics? We've got some questions coming in, but most of them are related to what's going to happen after June 1st. So I was going to give you the opportunity to share your other thoughts before we started talking about that.
Okay, great. Yeah, so I know people are anxious to know about reopening, and I thank all of y'all for taking time out of your day today to be with us, and hopefully we've shared some good information with you all. So my task for today was to kind of give you the tip sheet for remote appearances. And I started with just comb your hair. It's funny, two weeks ago, I did this seminar, or whatever you call this, online panel with the circuit judges, and I hadn't had a whole lot of the hearings yet. And all the attorneys were everybody was dressed in court attire, and everything was good. Well, since then, I've had some others, and, folks look like they just rolled out of bed, and it's just a little awkward. So I'm thinking, look in the mirror before you turn your camera on and comb your hair. Don't look like you just rolled out of bed. It's just awkward. For these hearings, you think about it, it really is still a court appearance. And, you may have your client there as well. And so they're going to see you too. So put on a nice shirt, comb your hair so it's not sticking up all crazy. And, it is nice because you don't really have to worry if you have shoes on or not. I don't think I'm going to see your feet, but put on a nice shirt. We're all going to be a little more relaxed. I know people have had asked questions about, well, what if my kids are home and they're in the background? Well, we don't want you locking your kids in the bedroom because that might be bad and you'll end up on one of our other dockets. But do the best you can, get them busy with a little project or something before you get on your call. But I don't think anybody's going to be, really frustrated or mad at you if a child interrupts or a dog barks or those types of things. One of the things so I'll kind of start at the beginning. So when you get invited to be in a virtual hearing, first of all, you may have to download something on your computer, Skype or Zoom, or I think that's mostly the only thing people are using right now. So make sure that you can get on that platform. Practice either with a colleague or, as Judge Brown indicated, most of the judges are getting on a little early anyway. So we want to make sure you're connected. We want to make sure we can hear you and that you've got sound and you've got camera. You can appear with just sound, but it is preferable. I really want to see your face. It helps me do my job, and I think it's another mechanism of communication, and so it's preferable if you have the camera set up as well, either built into your laptop or what have you. But don't be afraid to ask the judge can we do a practice round? I've never done this, or and I think most everybody would make time to try to help you and make sure you're comfortable with the technology before you get started as well. The more we do all this, the more we learn, and we realize, like, okay, yeah, what's in your background? You may not want something that's inappropriate in your background. Hopefully none of you have anything inappropriate in your backgrounds, but when you get on the call too, so once a hearing starts, you want to mute yourself. So you see, just like right now, Judge Brown and Judge Hagerty are muted. That's just to make sure, you know, like if Judge Hagerty's dog barks or something, well, she's not talking right now, so that sound doesn't disrupt, because it can be disruptive. So one thing we've learned too, I think it's the same with Skype, but with Zoom, so all of us have our name. You see all of our names appear on here. When you join in, sometimes your name will show up, sometimes it doesn't. So there is an option and I think you set it up when you log into Zoom or whatever, you put your name in. So put your whole name in. It's helpful to the judge to know who's in this little conference with me. It is, once you get in, there is a mechanism. If you right click on your picture box, there's a rename on the Zoom, and you can then type your name in. I don't think if you're calling in on a phone, I don't know that you're able to do that. And I've just had to ask people to identify themselves. So, but that's helpful if you can just make sure you have a name, your full name is reflected on when you join that platform. Looking at the camera, having good lighting, not, trying to, hide in the dark. It's just, again, it's just kind of weird. So try to be in good lighting. And let's see, we talked about recording. I'm looking at my little list here to see if there's anything I missed.
Judge Ward?
Yes, go ahead.
There were a couple of things that you and I had talked about. One was in regard to other mechanisms that are available on Zoom and Skype. We do have waiting rooms. So
yes.
If we have witnesses, they are able to be in a waiting area, not able to hear the conversation, but able to come in at the time when they need to testify. And then there are also breakout rooms in the event that counsel and their client need to go to a separate area so that they can be on video conference by themselves. So we do have that availability in both Zoom and Skype. And then I think the other thing we wanted to mention, Judge Ward, was to make sure that you are letting the court know who is in the room with the parties. I mean, these are public events unless it's like, a confidential hearing. But if you're on the circuit docket and there are other witnesses, we are likely to ask you whether other people are in the room who are going to be testifying, and then that separation would be required so that they're not sitting there listening to the testimony. And that came up on a couple of hearings that I had this week, where actually it didn't turn out to be someone that was related to the case, but it was the attorney's next client coming in, and he seemed to be talking and motioning to someone else, which made the other side concerned about, okay, is there a witness that's there listening? So, you want the room to be confidential to the extent that you're letting us know who else is in the room that may be listening to the call, that may be out of view of the camera.
Yeah, and another thing along those lines too, when we're having a hearing, one thing we've noticed with this type of technology is it's a little different for the judge and probably for the parties in terms of just controlling who's talking. And I think it's just more important than ever that we kind of observe some formalities of court. So, if you have an objection, just say objection. Judge, I have an objection. And then let the judge lead in terms of who's talking. So, okay, Mr. Kennedy, I'll hear your objection now. So because if you all start talking over each other like you do sometimes in court, same as in court, we can't hear either one of you when both people are talking. So let the judge lead. If you can, I promise you, I think every judge is saying, like, I want to hear from everybody. So I'm not going to, at some point, stop. I'm going to make sure I've heard from everybody I need to hear from and give both sides an opportunity to be heard. So just use those formalities of judge, I have an objection. You can try raising your hand. There's a little hand raise function, but we certainly don't mind if you would just say objection. Yeah, and that's probably the best practice there.
Judge Ward, a question for you, I think. If an attorney is planning to come and participate in the meeting or in the hearing in the courtroom, and they bring their laptop and an HDMI cable, is that what they need to bring, or what should they bring if the other party is going to be participating remotely to help them have best opportunity to see and hear everything that's going on?
I think, well, let's see. So I know in my courtroom now, I'm pretty sure that I have every cable that would be needed because what I anticipate getting the laptops that are coming. And so I've tried out some different things. And so I think I have, if they brought their laptop, I have the connectors. Now, I don't know that that's the case in every courtroom yet. And I know we'll be working on that because we want to be able to share these laptops that have been donated. So we'll be working on that. And I think probably it might be a situation where, I may have to go next door to Judge Brown and say, Judge Brown, I need to borrow your cable. but I'm not really that tech savvy, but yeah, there are certain cables that have to be connected to make that all work. My understanding, so there's a VGA cable, which is like this one that's got little teeth, and that's what makes things show up on the monitor and connect in. But yeah, I'm not sure. I just connect things and get it to work.
It's not a bad idea to bring an HDMI cable, because we do have the one with the serial port on it, with the prongs on it. We do have that one in every courtroom. They have that, but we may not have an HDMI. But there's some on each floor, so we can usually use someone else's. But if you have an extra one, it wouldn't hurt to bring it. And our plan is to have the additional laptops already available and plugged up to counsel table. But if you have your exhibits on your own laptop and you want to bring it, that's fine as well.
This question is maybe for all of you. I'm not really sure. It doesn't necessarily fall into any of the categories that we sort of talked about, I think. But if a party needs to file something and they can't get all of the documents that are needed to attach with that certified, or they just can't get final copies of them, or something else because of all that's going on with COVID-19, would it be, obviously if they're on a time restraint, there's a certain requirement, but if it's not so timely that they couldn't wait, would it be the court's preference that they go ahead and file with uncertified copies or partial documents and supplement later, or that they wait until they can get everything fully if it's still would be timely?
My answer would be if it would still be timely, it would be better to have the certified copies that you need. I guess the example I'm thinking of would be, I think maybe even the question said registering a foreign judgment. If you can't get a certified copy of the foreign judgment, I think each judge could sort of answer that individually, though, depending on what the circumstances are as well. So that might be something that the attorney would want to take up with that specific division, depending on what they're asking to file and what the underlying circumstances are. I don't know if anybody else has any other thoughts on that.
My thoughts are it's still a hearing and the rules of evidence still apply. My concern would be, any documents that you're trying to tender to the court, they've got to be subject to cross-examination. So I can't necessarily let you tender documents after the hearing's over unless there's a stipulation by both parties that certain things are going to come in afterwards. So my general thought on it is that you still have to be prepared and have the documents that are admissible for that hearing, assuming we're talking about a hearing that we're having.
And I think the question was more about when you're filing pleadings and you're attaching things. And so I don't know if that changes your answer or.
I think that probably both parties may likely have the same sorts of issues in terms of getting that documentation during this COVID-19 time frame where people have 50% or less of their workforce working. They may be slow in providing the certified records than normal. And so I feel like that would just be something that we would work out on a case-by-case. At least I would work out on a case-by-case basis because I think it's going to require a little give and take on the part of both parties for them to be able to move their cases forward, because, it may be documents for this person, but, at the same time, it could be something else that the other side needs. that we're going to have to make some sort of accommodation on. But we still have to follow the civil rules and rules of evidence. So, you know, perhaps they could agree to leave the record open to allow for the certified copies to come in, and then perhaps it's not submitted until that time, until all documents have been.
That would be a good thing to, I think, contact the court secretary and ask if you could email the judge or speak to the judge and do that ahead of time. I would prefer not to have that issue come up in the middle of something, because then the other side's going to object. If you could work all that out ahead of time and figure out, then it makes the hearing a lot smoother.
Judge Hagerty, I think we're having a lot of questions being asked about what things might look like when we come back.
Sure.
And so I want to maybe just give you one to start and then let you start after that.
Okay.
One of the questions that has been asked is whether after July 1st, do we think that hearings are still going to be occurring remotely? Is it going to be recommended that they're remote? Are people going to have the option to come in if they would like to? What do you anticipate?
Okay, so after June 1st, we're not going to be dealing with the same limitations on what the courts can do. You know, every county and jurisdiction in Kentucky is so different. Every courthouse setup is so different. The resources are so different. I think what the Chief Justice is envisioning is that the individual counties will have more discretion about how to handle hearings and whether they should be remote or in person on a docket-by-docket basis and a hearing-by-hearing basis. The main thing that we're going to see from the Chief Justice is that the safety guidelines that are in place for the Commonwealth of Kentucky will be in place for the courthouses. For instance, one conversation we had was originally what the Administrative Office of the Courts was envisioning was that each judicial center or courthouse may have up to 33% of their capacity in at any one time. And then after some discussion, you know, it was thought that that's not really very easy to monitor or enforce because there are so many different floors in the courthouse, et cetera. So a more realistic guideline would be that we have got to follow the social distancing guidelines, that everybody remains 6 feet apart. I do anticipate that there will be specific guidelines as to how many people can be in the courtroom at one time. For instance, it might be 8 or 10, something like that. We are not going to be limited to only remote hearings when we come back. However, we do have to be conscious of the fact that with following the guideline of everyone remaining 6 feet apart, there being 9 very active floors in the Judicial Center, or at least 8 on an everyday basis, you know, dockets running constantly. And as people come in to the Judicial Center, there'll be some kind of safety check in place. For sure, the sheriffs will be ensuring that everybody has a mask on. If some litigants don't have masks on, I think disposable ones will be provided. Administrative Office of the Courts is purchasing those to provide. As you come in, you'll have to apply hand sanitizer. There'll be a hand sanitizing station. You're going to see guidelines come out like, please limit the bags that you bring in. Litigants may not be able to bring in bags and purses because that's going to slow down entering the building even more, you know, because the sheriffs will have to, you know, deal with those in security. Then we're going to have the bottleneck of the 6 elevators on the first floor. And all of you all who litigate regularly know that's a bottleneck sometimes anyway, especially if one of the elevators goes out. So I think what the Chief Justice is anticipating is that we as a family court term and the circuit court term do continue many remote hearings because it's going to be easier as far as limiting the number of people we have in the building. And so when Judge Brown talked about, you know, 2 hours or less as sort of a rough guideline for the hearings that would be done remotely. We will probably put some guidelines like that in place and get out to you all as to what to expect. Our dependency dockets, our domestic violence dockets, and our paternity dockets are really the most challenging things, because those are more, I wouldn't say cattle call dockets, but they're not as time specific in terms of scheduling. And so we will typically have, maybe 30 or more people show up for that docket on each day. So if you have 4 family court divisions on each floor, and on Tuesday, Wednesday, and Thursday, all of us have at least one docket going, that's a lot of people out there. So in order to keep the 6-foot distancing, we're going to have to do scheduling with that in mind. We are going to get out very specific, easy to use guidelines before June 1st. We're all in the process of working on that right now. For instance, Judge McDonald is working with the Jefferson County Attorney Paternity Division, Child Support Division, to look at those dockets and see, ways that we can keep the foot traffic on those dockets down. We are currently doing remote hearings on some of our dependency cases, because right now we can only do emergency cases in person, but we're trying to take care of some of those cases remotely to ease the pressure on our dockets when we come back after June 1st. We're going to do a tip sheet, and it'll be in addition to what Judge Ward has prepared today. I'm sure we'll be adding to it. Judge Kurtstetter is working on that with us. We'll do a tip sheet for remote hearings for pro se litigants. It'll be in a format that pro se litigants can use it as well. So it might seem oversimple to counsel, but we don't want to have multiple tip sheets. And the Administrative Office of the Courts is working on a video for remote hearings that'll be shared on the Court of Justice website, hopefully to help people use the remote platforms more easily as well. There will be a lot of use of remote hearings, but we will be able to do in-person hearings. We will not be limited to only remote after June 1st. Let's see. And, the Administrative Office of Courts is doing everything they can to provide to us what we need. Like I said, though, when you enter, you'll have to have a mask on. Counsel, I'm anticipating, will be able to bring in briefcases and things like that. But litigants, witnesses will be limited to what bags they're able to bring into the building. As you get off the elevators, there's going to be a hand sanitizing station. As you come into the courtroom, there's going to be a hand sanitizing station, and you're expected to use it again as you exit the courtroom. The Administrative Office of the Courts is working with the Public Health Department on these guidelines. So in order to follow the safety guidelines, things are going to be pretty slow moving, as far as people coming in and out. So that will sort of guide us with the schedule in person and what we try to do remotely. And I'm happy to answer more specific questions, or if any of the other judges want to chime in about what you envision for June 1st. I do think we will have a lot of discretion about how we do our scheduling. I think that the guidance from the Supreme Court is going to be more in terms of how we follow the social distancing and other safety guidelines.
Judge Hagerty, I have received some questions from individuals who may have an underlying health condition, or maybe pregnant, or other issues relating to their health, and they have asked if they would have the option to appear remotely, and I have said yes, you would. I mean, it's basically going to be based on your personal situation. So if you ask for that opportunity, we're going to definitely try to accommodate that for whatever the reason is.
That's a great point. And that'll apply for witnesses, litigants, attorneys. We want everybody to be safe. I mean, obviously we have got to increase how much accessibility you have and your clients have, but we need to do it safely. So that's a great point.
Judge,
we had the provisions in place that if you were sick, that you should not come to court. And you all would be amazed to know how many people came to court sick anyway, that had to be turned away downstairs or they were up here about to come into the courtroom, and we had to, reschedule their case because they were obviously symptomatic of something. What we didn't know, but they were definitely showing symptoms of some issue. And so just to be on the safe side, we asked them to go ahead and reschedule, but that's really a part of the Supreme Court order, that if you are sick, you shouldn't come. You can ask for a reschedule and it will be granted.
We'll make sure we include all that language again when we, send our guidelines out for what happens after June 1st. In talking about planning along with the Public Health Department, one thing they're looking at, I don't know if we'll have the resources to do that because of our volume, but one thing they're looking at is if there would be public health, Metro Health employees available to do some kind of scan to check for temperatures as people come in. I don't know if we'll have that, but they're looking at whether that's an option. And, just keep in mind that the Hall of Justice is the most busy building in the state in terms of traffic, and we're second. The Judicial Center is second. So that kind of gives you an idea of the challenges that we have with trying to observe the safety guidelines for COVID.
Judge Hagerty, you've mentioned several times about having information to put out to folks, and I hope that everybody listening is getting that information already, but if they are not, could you please tell folks how to make sure they're getting that?
Yes, and I think Judge Ward is going to share the screen. We get out a very wide distribution list by email from the Administrative Office of the Courts here in Jefferson County, and Kelly Williamson is the person who sends that out. Her email address is Kelly, Kelly, capital W at kycourts.net. So if you have gotten the information during this pandemic that we have sent out because it was forwarded to you from someone and you didn't get it directly from us, Kelly Williamson's the person you need to contact to get on our email distribution list. We are also going to be posting things on the Kentucky Courts website. And that is KY Courts, spelled out, KYCOURTS.gov. And then when you get to that website, you can select Family Court. And then when you get to Family Court, you can select Jefferson County. And that'll give you the information that we've shared so far. And we're going to, keep pushing out information those two ways to keep people informed.
Yeah, right here is where the motion hour, if you're not familiar with how to get the motion hour, you should be seeing my screen right now. And so I'm just on the kycourts.gov website. Follow those links that Judge Hagerty was talking about. And you scroll down. I'm now on the Jefferson County part of the page. And you click on the motion hour. And then I think all 10 divisions are getting their motion hours posted. So you would be able to see the pre-rulings for the motion hours. They should all be on there. So we showed you Kelly's email. Again, that's Kelly W at kycourts.net, or go to that website. Was there anything else you wanted me to share, Judge Hagerty?
I don't think so right now. Like I said, we are working on the tip sheet. A couple of attorneys had shared with us what Fayette County sent out to explain what they're doing during the partial shutdown of the courts. And we really liked the way it looked. It was sort of just a one-page synopsis of how each docket was working. So we're going to do something like that for what's going to happen after June 1st. As soon as that's complete, we will send that out. Judge McDonald mentioned that the motion hours are sort of, that we're consistently reviewing motion hour and getting out rulings, but everybody's doing it a little differently. We'll strive to be as simplistic about it when we get back after June 1st. I know that some attorneys had shared with us, what different counties were doing. It's all over the board, in talking with these judges on the statewide panel. Some counties are doing nothing except for the emergencies as identified in the Supreme Court order. Nothing on motion hour, no circuit things, nothing at all. Some jurisdictions aren't doing juvenile court at all. Because there were some concerns, and I don't mean in Kentucky, but I mean, we're sort of plugged into nationwide courts as well, and we're looking at some of them for benchmarks and guidelines, and it's kind of all over the place. So we'll try to be as accessible and as consistent as we can to make it easy for you, and we'll try to share information. If at any point you have a question, especially if it's a specific division, don't hesitate to reach out to the secretary or the judge, via email. We're all open to answering questions and giving guidance. And we want to be able to help you so that you can help your clients.
One thing we haven't mentioned today, Judge Hagerty, the recent order that you did, the standing order regarding mediation. You might want to tell people about that. Sure.
And that went out on the distribution list that we've talked about. We haven't posted it on the website yet, but we will. Basically, we did a local standing order that if there is a current order to mediation from any of the 10 family courts, that has to be honored by attending remote mediation, unless the parties agree to follow safety guidelines and do in-person mediation. The reason we went ahead and did that was we were getting comments from attorneys that in some cases refusing to do mediations remotely and saying, I want to wait and do them in person, could possibly be being used as a stalling tactic, that kind of thing. Also, we wanted to honor the Supreme Court order, which makes it clear attorneys should keep litigating and preparing cases and preparing to be heard in court after June 1st. So we wanted to keep things moving. So if you haven't gotten a copy of that, just email me and we'll make sure that you get it. But that went out on the email distribution that Kelly Williamson does. So make sure you're on her list as well.
We've got about 2 minutes left. And I just wanted to say thank you to all of you judges for participating. Thank you to the LBA for helping put this on. We know that these are trying times for everyone. And as a representative of the bar, I would say thank you to the 4 of you and your colleagues for helping things move along as much as they can. Thank you, Judge Hagerty, for participating in this statewide task force. This is quite a task to figure out how we are going to reopen. And a lot of the questions that I've seen today dealt with things that it sounds like you're working on, but you don't know the answers yet. How are you going to deal with large dockets for paternity, for example? And I think all those things are in the works. And just thank you. And in a minute, if there's anything any of you would like to say quickly, some extra tips or anything to anyone, now's your chance.